Dear students, I have come to the last module of Consumer Protection Act. This is two topics I am going to cover: Consumer Protection Authority or CCPA and remedies available to the aggrieved consumer. Also one more topic, the comparison between Consumer Protection Act 1986 and Consumer Protection Act 2019. So you will get to know an idea what all changes have made in the new act when we compare with the old act. So three topics we are going to cover: Central Consumer Protection Authority or CCPA, remedies available to the aggrieved consumer, and the comparison of both the Consumer Protection Acts. Now, role of CCPA. So this is to promote the rights of consumers as a group. If a group of people invested in a financial institution, they cheated them. So that meaning as a group how they can protect their rights. Next is to prevent unfair trade practices, overcharging the products, giving wrong services, false claims. All these are unfair trade practices. Next is prevent violation of consumer rights. We have certain rights as consumers: right to education, right to safety, right to know about the product, right to select, all this. If any of these rights are violated, CCPA can take action. Then to prevent misleading advertisements. If a company is giving any misleading advertisement about the goods or services, that will also CCPA will try to protect that. Now the penalty to the manufacturer for false or misleading advertisement is rupees 10 lakhs or imprisonment for a term of 2 years. Any company or any manufacturer selling something or any service provider providing services, if they are giving any wrong information, we have seen many instances recently then where celebrities were involved, they were asked to pay fine or to remove that advertisement, remove the false statements. So here this fine is 10 lakhs rupees or 2 years imprisonment. Now consumer get an additional point of access of justice through CCPA. So instead of going to the consumer court, the CCPA will give them additional point of access. They can approach CCPA directly before going to the consumer court. Now mediation process I have to explain. So an alternate dispute resolution mechanism is provided through CCPA. That is what I have mentioned. Instead of the consumer going to the consumer court, they can approach the CCPA. So mediation cells are to be attached to the consumer forums. Every consumer commission, district, state or national, they have a mediation cell. But appeal is not possible against the settlement through mediation. Whereas we have seen that consumer commission, district, state or national, if they are giving any verdict, consumers have got the right to go for appeal. Whereas in the case of mediation, appeal is not possible. Now product liability. A manufacturer or service provider is responsible for the product quality. Whatever they are claiming, the product quality should be maintained. Deficiency in the product quality will make them responsible for product liability. Product liability is punishable. Now basis for deciding the product liability. Manufacturing defect is there, design defect is there, deviation from manufacturing specifications, not confronting to express warranty. We know that warranties are there, conditions are there. So if they are not following that warranty, express warranty, then not providing adequate instructions for correct use. If you are buying a pressure cooker, mixie, that instruction will be there. Read the instructions before using that item. So that if that instruction is not there, services provided are imperfect. In any of this case, it is decided that product liability, manufacturer or service provider has to bear the expenses and they have to pay for the compensation. Now members of the Central Council, how CCPA is constituted? Their role is that of advisory council. Central Minister in charge of consumer affairs will be the chairperson, and other members with common interest will be nominated by the central government. So it's a nominated members from by the central government. Now members of the State Council. Central Council is there. Similarly, state councils are also there. State Minister in charge of consumer affairs is the chairperson, and not exceeding 10 other members with similar interests will be nominated by the state government. This is how State Council is constituted. Now, remedies available for an aggrieved consumer. What are the remedies? This is the second topic I am covering in this module. Grievance redressal mechanism of the service provider. See, if you are not happy with the item purchased or if you are not happy with the service got, Then first is, instead of going to the consumer court, what you can do, you can directly approach the manufacturer or the service provider by sending a legal notice. Now, if they are not replying, then file the consumer complaint. Then if they feel that there is a reason for mediation or the case can be settled through mediation, they will ask for mediation and review the application. If the mediation, if after that you feel that review is possible, now you can also file for appeal. District verdict or order, if you are not happy, you can appeal to State Commission. State Commission appeal, if you are not order, if you are not happy, you can appeal to National Commission. National Commission order, if you are not happy, you can apply to Supreme Court. So filing appeal with the National Commission is also possible. Now coming to the third point. I'm going to compare the Consumer Protection Act 1986 and Consumer Protection Act 2019. So if you see the ambit of law, first one, Consumer Protection Act. All goods and services are included, but free and personal services are excluded. That was the time 1986. Whereas Consumer Protection Act 2019, all goods and services, including telecom, house construction, and different modes of transaction are included. Online payment, bank frauds, everything, house construction, RERA, that is very important. Those who, if a builder will cheat them, or if anyone want to purchase a land, if you got cheated, you have the right to take action. But free and personal services are excluded in both the acts. Second point is unfair trade practices. In the 1986 Act, includes 6 unfair trade practices, including false representation and misleading advertisements. Whereas in the new Act, not issuing a bill, refusing to accept the item returned within 30 days, and disclosure of personal information are included under unfair trade practices. This is the need of the hour. When you go to a KFC restaurant, you can see that if you're not getting a bill for this item you purchased, whatever the purchase is free. That meaning it's an instruction under the Consumer Protection Act, not issuing a bill, refusing to accept. If you're not happy, the customer is not happy, manufacturer or service provider has to take back the item. Then third thing is disclosure of personal information. We share our Aadhaar card information, PAN card information, everything with for the bank account details or those who are providing service, all this. So if they're giving our personal information to someone without our knowledge or permission, then it also, as per Consumer Protection Act 2019, they can take action. Now, Product Liability 1986 Act, there is no provision, but 2019 Act, there is a provision for product liability. And Unfair Contracts 1986, there is no Act, there is no provision, but in the 2019 Act, there is provision. Now, Central Protection Council. Now, 1986 Act, the idea was to protect the rights of consumers. Whereas in the 2019 Act, they are coming as advisory bodies for promotion of customer rights. We have seen that what is the role of CCPA. CCPA is acting as an advisory body. So instead of going to the consumer court directly, consumer can first approach the CCPA. So that's an advisory body. They will advise the customers properly. Now, regulator. In the case of 1986 Act, there was no regulator at that time. Whereas in the case of 2019 Act, regulator is there, and that is the CCPA. And jurisdiction of commissions. In the case of 1986 Act, up to 20 lakhs with district courts you have to file. And up 20 lakhs to 1 crore is the state commission you have to file. And above 1 crore is with the national commission. Whereas in the case of 2019 Act, up to rupees 1 crore with the district commission you have to file the case. 1 crore to 10 crore with the state commission you have to file. And above 10 crore with the national commission you have to file. Now, composition of commissions, how commissions are constituted. As per the 1986 Act, district by the current or former district judge and 2 members. State commission by the current or former High Court judge and 4 members. National commission, current or former Supreme Court judge and 4 members. Whereas as per the new Act, district, in the case of district commission, president and at least 2 members. And in the case of state and national commissions, president and at least 4 members. This is how the composition of commissions are constituted. Now, appointment. Now, in the case of 1986 Act, selection committee to recommend members. It was members for the commission are recommended, or selection committee was there to recommend the members. Whereas in 2019 Act, central government appoints through notification. So there is a drastic change. One is recommendation from the selection committee, that is the earlier practice, but now it is the central government appoints through notification. So whoever capable, they can apply as per the request for the notification. Now, alternate disputes redressal mechanism. As per the earlier Act, there was no alternate dispute mechanism. There was no provision. Whereas in the 2019 Act, yes, there is a provision for mediation. Now, penalty for not complying with orders of the Commission. 1986 Act, 1 month to 3 years of imprisonment and fine between rupees 2,000 to rupees 10,000. As per the 2019 Act, imprisonment up to 3 years and fine from rupees 25,000 to rupees 1 lakh or both. In the case of e-commerce now we do everything online. So 1986 Act, there was no provision to protect the interest of consumers if you are doing anything through e-commerce. Whereas 2019 Act, e-commerce and direct selling are included. So this is what I wanted to explain in this module. 3 topics we covered. One is CCPA, second is consumer rights, aggrieved consumers' rights, and third one is comparison of Consumer Protection Act 1986 and Consumer Protection Act 2019. So with this, we have completed the Consumer Protection Act. Thank you for patiently listening. Happy learning. Thank you.